Right friends, welcome back to 5th capsule. This is on most important topic, CAUVERY dispute, and in capsule 4 we deliberated on the situation of availability of water in our country. Please view that capsule before viewing this capsule. And another important aspect I would like to tell you before going into the details is, long ago the lower riparian states developed irrigation systems, and in recent times, that means during the past 40-50 years, upper riparian states are developing irrigation systems, and for any river the dispute is with regard to the states, that is the lower riparian states which developed irrigation systems almost for the past 100 to 200 years, and the upper riparian states which are developing irrigation systems in recent times. If you look at CAUVERY river, the lower riparian state, that is Tamil Nadu, developed well laid out irrigation systems in Tanjavur, Nagapattinam and Thiruvarur districts. Basically these three districts almost falls under the CAUVERY delta, and they developed well laid out irrigation systems almost hundreds of years ago. And if you look at the upper riparian state Karnataka, the developments are most recent in 20th century. Similarly, if you look at the Krishna river, the lower riparian state Andhra Pradesh developed well laid out irrigation system almost 150 years ago, and during the past 50 years the upper riparian state Karnataka is developing irrigation projects. If you look at Godavari, the delta is almost 150 years old. The barrage was constructed by Sir Arthur Cotton, and the upper riparian states now Telangana as well as Maharashtra are developing irrigation projects. And if you look at Mahanadi, the Mahanadi irrigation system is also old in Mahanadi delta area of Odisha, and now the upper riparian state Chhattisgarh is developing irrigation projects. So the bone of contention is between Odisha and Chhattisgarh. So the dispute arose between the lower riparian state and the upper riparian states. Right? Let us look at three principles of water allocation. There are three principles. That means how the water is to be shared. If you look at from that perspective, there are three principles. One is Harmon doctrine. This Judson-Harmon doctrine prescribes that upstream state will have complete freedom over water flows within its territory. Upstream state will have complete freedom over water flows within its territory. This is known as territorial sovereignty. And this principle does not bother any impact that may create in the downstream states. As water is flowing in my state, so I should have total sovereign right. So that is all about Harmon doctrine. And this theory, that means if you apply this theory for CAUVERY dispute, Karnataka will have right to use waters in whatever way it wants. This is known as Harmon doctrine. If you look at the doctrine of history means downstream states, as I have already told you, developed well laid out irrigation systems long back, and this theory gives right to lower riparian states. And this history doctrine, otherwise known as prescriptive theory or right of appropriation, whatever the term you use, gives right to the lower riparian state, and in this case Tamil Nadu will have the right if you apply this doctrine of history, because almost 2000 years ago Karikala Chola developed a water diversion system on river CAUVERY almost 2000 years ago. So if you look at history, Tamil Nadu will have absolute rights. And now the most accepted doctrine is Hobbes doctrine. It is nothing but mutual transfer of rights. You may ask, who is Hobbes? Hobbes is a famous philosopher, and his book of 1651, Leviathan, established social contract theory, and as per his doctrine, the rights has to be based on negotiations. That means here People have to give up individual liberty. People or states have to give up individual liberty in exchange for some common security or mutual benefit. So, it is nothing but mutual transfer of rights, and this theory is being followed across the world. That means through mutual negotiations, river waters are to be shared. Right, friends? Look at the relevant provisions of Indian Constitution. Please don't forget. Most of these provisions of Indian Constitution have drawn from Government of India Act of 1935. In fact, British anticipated the same problem and incorporated most of the provisions what we have in Government of India Act of 1935. And if you look at the present provisions of Indian Constitution, entry 17 in the state list, all of you are well aware, 7th schedule of the Constitution as per Article 246 gives union list, state list and concurrent list, and this is as per 17 in the state list. So, water supplies, irrigation, canals, drainage, these all comes under state list. That means state has got exclusive powers. But for the interstate rivers, the entry in 56 will prevail, that is in the union list. So, for interstate rivers or river valleys, central government has got authority as per item number 56 of the union list. And if you look at Article 262 of the Indian Constitution, Article 262 grants Parliament the right to legislate over the matters in entry 56. That means this interstate disputes of rivers will come under the purview of Parliament as per Article 262. And most important point is Supreme Court has got no jurisdiction in respect of any dispute or complaint. With respect to any dispute or complaint, as far as interstate rivers are concerned, Supreme Court cannot intervene. Supreme Court cannot say that this should be the allocation of particular state, but now Supreme Court is interfering only to look at the effect of tribunal order in CAUVERY dispute. CAUVERY River Water Tribunal has given certain percentage of water share to each and every state, and Supreme Court has no authority to look at these percentages. Supreme Court has got authority only to look at the implementation of the award, because necessary framework was not devised by the center in this case. So, here it is very clear, as per entry 17, water is state list, but interstate waters or interstate rivers comes under union list of 56, that is item number 56. And ultimately, Article 262 looks at the Parliament the right to legislate with regard to interstate rivers. So, this is all about the constitutional provisions. And Interstate River Water Disputes Act 1956 was brought by the Union government. Basically, it was legislated to deal with the conflicts. When direct negotiations have failed, tribunals can be established by the center. The most important aspect of this Interstate River Water Disputes Act 1956 is when direct negotiations have failed. First step is to look at negotiations among the states, and if direct negotiations failed, tribunals can be established by the center. And here one important point is state government has to make request to the central government for the establishment of a tribunal. And tribunal's composition consists of chairman and 2 other members to be nominated by the Chief Justice of India, and the Chief Justice has to nominate from among the persons who are judges of the Supreme Court. And incidentally, I would like to tell you, out of 18 major rivers, 17 major rivers are interstate rivers. All of you are familiar with water disputes with regard to Krishna River, Narmada River, Kaveri River. So, these disputes are coming time and again because most of the rivers are interstate rivers. and the decision to be published and is final and binding on the parties. This is as per Interstate River Water Disputes Act of 1956. But if a state disobeys, then what next? That is not clear. Then jurisdiction of Supreme Court and other courts in respect of the dispute is barred. Supreme Court cannot intervene as far as the allocation of waters to various states is concerned. And states several times refuse to accept the decisions of tribunals. So, the tribunal cannot do anything if the state government fails to cooperate. And though the Act specifies clear procedures for handling disputes, states in general are not in a mood to accept. This is all about Interstate River Water Disputes Act. And before going ahead, let us look at the Cauvery River. Cauvery River, please look into this slide, originates in Karnataka, that is the Kodagu district, Talakaveri, and it flows through Karnataka and Tamil Nadu. It empties into Bay of Bengal through its principal mouths in Pumpuhar region of Tamil Nadu, and the river basin involves 4 states. River basin involves 4 states, and Tamil Nadu has got maximum area under river basin, more than 50%. Tamil Nadu has got more than 43,000 square kilometers. Karnataka has got more than 34,000. Kerala has got 2,866 square kilometers, and Pondicherry is a negligible area of 160 square kilometers. And the famous Sivanasamudra waterfalls are situated on this river, and I have already told you 2000-year-old Grand Anicut or water diversion scheme in the present day Tamil Nadu was constructed by Karikala Chola and considered to be one of the oldest water flow management system and the oldest in the subcontinent. And if you look at the projects on the river basin, this Harangi, Hemavati, Kabini. This Harangi, Hemavati, Kabini, these 3 were constructed in the later half of 20th century, and Krishnarajasagar Dam was constructed in 1930s, and these 4 are situated in Karnataka. This Harangi, Hemavati, Kabini, these are tributaries of Cauvery, and these 4 are in Karnataka. One is Harangi, the second one is Hemavati, then the third one is Kabini and Krishnarajasagar. If you look at Tamil Nadu has constructed this Mettur Dam. Mettur Dam was constructed in 1930s, and Bhavani Dam on the tributary was constructed in 1950s, and Grand Anicut, as per the history, this Grand Anicut is more than 2000 year old if you look at the history, and it was constructed by Karikala Chola, but the present form was constructed almost 200 years ago. And Lower Kalarun Anicut, and this Lower Kalarun Anicut, this is situated on one of the distributaries of Cauvery River. And one more aspect is Amaravati Dam is also there on one of the tributaries of Cauvery, and Amaravati is also situated in Tamil Nadu, right? So let us go back to history of Cauvery agreements. 2 things. One thing, as I have already told you, first thing is the irrigated area in Tamil Nadu was developed long back. And second important point is the agreements during British era were in favor of Madras state. In those days, the present day Karnataka, that means the region of this Cauvery, was under Mysore princely state, and the present day Tamil Nadu was under British Madras presidency, and Madras presidency versus princely state of Mysore, and the water agreements of 1892 as well as 1924 were between the then Madras state of British presidency as well as Mysore state, and experts felt that those agreements were clearly in favor of Madras presidency. That is the crux of the problem now. And if you look at 1892 agreement, British government awarded Madras province, the lower riparian state, veto power over all the irrigation works undertaken by Mysore. Mysore is upper riparian state. So if Mysore state wants to construct any project in those days, it requires approval of Madras state. That means Madras province of British. And 1924 agreement was concluded between Madras and Mysore, valid for 50 years, and subsequently this Krishnarajasagar Dam and Mettur Dam were constructed in the year 1932 and 1934 respectively, and the agreement ended in 1974, and subsequently conflict started in the year 1983. Tamil Nadu Farmers Society filed a petition in Supreme Court for greater share in Cauvery waters, and in the year 1990, Cauvery Water Disputes Tribunal was formed under Interstate Water Disputes Act of 1956, and here during the later half of 20th century, Karnataka government constructed Kabini, Hemavati, Harangi dams in Cauvery basin and expanded Ayakat, and at the same time Tamil Nadu also expanded the Ayakat substantially, and tribunal after 17 years delivered its final verdict on 5th February 2007, and the allocations I have given here: Tamil Nadu 419 TMC, Karnataka 270 TMC, Kerala 30 TMC, Puducherry 7 TMC, and here Karnataka has to release every year 192 TMC feet of water. TMC means 1000 million cubic feet. So every year Karnataka has to release 192 TMC of water to Tamil Nadu in a normal year, and if the monsoon is not normal, then they have to release proportionately, and 192 TMC has to be released by Karnataka, and the remaining TMC, that is 419 minus 192, which comes to 227, will be received by Tamil Nadu from the catchment area in Tamil Nadu. And finally, in the year 2013, based on the directions of Supreme Court, Indian government notified the award of Cauvery Water Disputes Tribunal or sharing the waters of Cauvery in the Gazette. And Karnataka is not happy with the tribunal award, and it approached Supreme Court. The matter is pending with 3-judge bench, and Karnataka's viewpoint and Tamil Nadu's viewpoint I have given here. Karnataka's viewpoint is 1892 and 1924 agreements are skewed towards the then Madras state. Karnataka feels that those were the agreements between two unequal partners. British has got supremacy over the princely states, and as such Karnataka says that those agreements were between unequal partners, and 2007 tribunal award has not considered this anomaly, and simply they have gone by the previous agreements, and tribunal as such gave higher share of water to Tamil Nadu. And Tamil Nadu has got bigger farmland, and it grows 3 crops annually. One is Kuruvai, Samba and Taladi. And Karnataka's drinking water requirements to cities like Bengaluru, Mysuru are not considered. And this is the viewpoint of Karnataka. And if you look at Tamil Nadu's viewpoint, Kalanai water diversion scheme built by Karikala Chola is almost 2000-year-old, and it is one of the oldest water diversion schemes in the history of the world, and so it demands more water for their farmers. Then Tamil Nadu's viewpoint is Karnataka is constructing check dams or dams without proper approvals, and there is no transparency in the information given by Karnataka with regard to availability of water in their reservoirs. Karnataka is diverting water for industries illegally, and why center is not constituting Cauvery Management Board. So these are the questions raised by Tamil Nadu. So in a nutshell, Karnataka is not happy with the tribunal's award, and it approached Supreme Court, and the matter is pending with 3-judge bench of Supreme Court, and Tamil Nadu's viewpoint is historically we are using Kaveri waters. So if you look at the history, if you look at the theory of prior appropriation, we require more water. And Karnataka's viewpoint is in the British era, maximum water was given to Madras state, so that anomaly is to be corrected by the tribunal, but tribunal award which was given in 2007 has not taken this aspect into consideration. So this is the viewpoint of Karnataka, this is the viewpoint of Tamil Nadu, and let us look at what are the present drawbacks of water disputes and what is the need of the hour. With these two things, I would like to close this lecture. First one is what are the present drawbacks. National Water Development Agency was created in 1982 for optimum utilization of water resources, but no tangible outcome. At the same time, National Water Resources Council was created with Chief Ministers as members in 1983 and Prime Minister as the chairman, but it could not solve any of the water disputes in the country. Then Section 6 of the Interstate Water Dispute Act of 1956 says that the decision is final and binding on the parties. The centre cannot enforce if the state government refuses to accept the award. Then Section 6A of the same Act provides for an agency to implement the award, but such an agency cannot function without the cooperation of the states. And the interesting point here is Cauvery Tribunal took 17 years to publish the award, and subsequently government took 6 years to publish it in the official gazette, and till date Cauvery Management Board was not created by the central government. Right? As per Section 11 of the same Act, Supreme Court or any other court will not have any jurisdiction over the tribunal verdict, and central government most of the times is acting as a mere spectator. So these are the present drawbacks, and finally what needs to be done. Actually the most important aspect is water conservation methods needs improvement immediately. The water guzzling crops like rice, sugarcane needs immediate review and less water consumption even for crops like rice and sugarcane is the need of the hour, and as such we have to go for better agricultural practices. That is the most pressing need in the country. And here what needs to be done? Before going into this slide, please recapitulate whatever you have learnt in the 4th capsule, that is India and water. Now after recapitulation of those aspects, I have added some more points here. These points particularly pertain to water disputes and what is the institutional mechanism to be improved. Tribunal awards should have the same force like the decree of the Supreme Court. This is there as per 56th Act, but if you look at the implementation, it is not being implemented because one or the other states are approaching Supreme Court once the tribunal publishes award. Then time limits must be specified in constituting tribunals and delivering the decisions. Some timeline is given as per 1956 Act, but there are so many ifs and buts, and a specific timeline must be given so as to publish the award at the same time for its strict implementation, just like the decree of the Supreme Court. And centre should have the power to appoint a tribunal without being asked to do so by a state government. At present, state government is asking centre to appoint a tribunal, and centre should have the power to appoint a tribunal as and when it feels necessary. And at the same time, establishment of national level data bank and information system is the need of the hour, and creation of quasi-independent hierarchy institutions to manage the allocations of water. That means separate institutions to manage the availability of water, to manage the cropping pattern, to manage the distribution of water. All these things should be looked after by a separate independent hierarchy of institutions in the country. And permanent institutions with rotating membership is the need of the hour. Right friends, water is a delicate subject and strong institutional mechanism is the need of the hour. At the same time, water conservation and efficient use of water is the utmost necessity. Right friends, with this, let us conclude this topic, Cauvery dispute. Please do join for other capsules. Have a nice day. Thank you.